In 1563, a man was arrested for treason in the city of Prague, where three different governments simultaneously claimed legal jurisdiction, each government operating under laws written in completely different languages that the accused could not read or understand, none of which the accused could read. After 11 months in prison, he was released not because he was proven innocent, but because the presiding judges representing three different legal systems could not reach any agreement on which specific legal code should properly apply to the case, when the very definition of the crime itself changed fundamentally depending on which translation of which law any given judge chose to consult. In 16th century Prague, the Holy Roman Emperor issued laws in Latin and German. The Bohemian nobility, maintaining their traditional local autonomy and cultural identity, wrote and enacted their own separate laws exclusively in the Czech language, creating a parallel legal system. And the city's courts had to navigate all three competing legal systems. When a crime crossed these linguistic boundaries, the law itself became unstable. A word in Latin did not mean the same thing in German, and neither matched the Czech. The case that revealed this chaos involved a Czech nobleman named Václav of Luditz. The specific case that dramatically revealed this underlying linguistic and legal chaos involved a prominent Czech nobleman named Václav of Luditz, who found himself caught between three incompatible legal systems simultaneously, each with a different legal standard and carrying a different penalty. Each language version of the treason charge came with a fundamentally different legal standard for proof and conviction, and each version also carried completely different penalties ranging from fines to execution. Imperial law, as written and codified in formal Latin, specifically defined the crime of treason as any act whatsoever, contra majestatem, which translates as against the majesty of the emperor himself, an intentionally broad and deliberately vague legal formulation. German law used Hochverrat, requiring proof of intent to harm the emperor directly. A narrower definition, much harder to prove in court. Czech law called it rada, applying only to betrayal of one's oath-sworn lord. Václav swore oaths to the Bohemian king, not the emperor, though legally the same person. But they were separate offices under Czech law. But according to the specific provisions and traditional interpretations of Czech law, the emperor and the Bohemian king were legally considered two entirely separate and distinct offices despite being held by the same individual person. And none agreed on what the crime actually was under any system. Václav had refused to send troops to support an imperial campaign in Hungary. The factual action at the center of all dispute was straightforward. Václav had explicitly refused to send his troops and soldiers to provide military support for an ongoing imperial military campaign being conducted in the Kingdom of Hungary. In German, no, because he had not intended direct harm to the emperor's person. In Czech, absolutely not, because he owed troops to the Bohemian king, not the emperor. From the Czech legal perspective, the answer was absolutely and unequivocally not treason, because Václav owed his military service obligations to the Bohemian king alone, not to the emperor, even though the same man held both titles. One from the imperial chancery, one from the Bohemian estates, one from the city legal office. And all three translations disagreed, not on the facts, but on what the facts meant legally. And all three officially requested translations fundamentally disagreed with one another, not on the basic facts of what had actually occurred, but rather on what those undisputed facts actually meant from a legal standpoint under their respective systems. The Bohemian translation used pan, meaning lord, emphasizing personal feudal bonds. The city translation used vladarer, meaning ruler, emphasizing administrative authority. And each word carried different legal implications, creating entirely different crimes. Václav sat in prison 11 months, while judges debated not evidence, not intent, but translations. Václav sat imprisoned in a cold stone cell for 11 long months, while the judges endlessly debated not the evidence presented, not the intent behind his actions, but merely the correct translations of legal terminology between three different languages. And then something legally and politically unexpected happened that would change the entire trajectory of the case. The Bohemian estates collectively submitted an extensive legal brief arguing forcefully that Czech law must take precedence. And city courts, caught in the middle, declared they lacked jurisdiction entirely. No agreement was reached, so the case simply stopped. Václav was released in March 1564, not acquitted, not pardoned. Václav was officially released from prison in March of 1564, not acquitted of the charges, not pardoned by any authority, but simply released because the legal process itself had completely broken down. Official records do not call it justice, but suspension of proceedings, pending clarification. The official court records preserved in the archives do not characterize this outcome as justice being served, but rather use the formal bureaucratic phrase suspension of proceedings pending clarification of jurisdictional authority, which never actually came. This was not isolated. Historian Robert Evans documented over 40 similar legal collapses in Prague. This was demonstrably not an isolated or exceptional incident, as prominent historian Robert Evans systematically documented over 40 remarkably similar legal collapses and jurisdictional failures occurring in Prague between 1550 and 1590 alone. Each of these 40 documented cases involved fundamentally conflicting translations of imperial edicts and proclamations, and virtually each one ended in some form of legal paralysis or quiet administrative abandonment, showing systemic dysfunction. But when someone tested boundaries, the structure revealed itself as negotiation, not code. Chaos went deeper, even within single languages. Law remained unstable. Latin legal terms from Roman law had no direct Czech equivalents, forcing translators to invent new words or borrow German terms, creating hybrid vocabulary nobody understood. This problem forced legal translators to either invent entirely new Czech words with uncertain meanings, or alternatively borrow existing German terms wholesale, thereby creating hybrid legal vocabulary that literally nobody in any language community fully understood. One particularly revealing case from 1570 turned entirely and exclusively on the proper legal translation of the single Latin word dominium into either the German term Herrschaft or alternatively the Czech term panství, creating completely different legal outcomes. While panství implied personal authority over people living there, which changed who paid taxes to whom under each interpretation. And the judge could not resolve it because dominium could mean either both or neither. Legal historian Winfried Eberhard called this linguistic legal pluralism, not a bug but the system itself. The distinguished legal historian Winfried Eberhard specifically called this phenomenon linguistic legal pluralism, and importantly argued it was not merely a bug or flaw in the system, but rather represented the fundamental structure of the system itself. And imposing a single language would have triggered revolts across territories. And imposing a single unified language across all territories would have immediately triggered widespread revolts and uprisings across the empire's diverse territories, making linguistic and legal uniformity politically impossible to achieve. Most times it functioned because most people never tested the boundaries. But when tested, law was what judges decided words meant that day, changing with who was present. But when someone did test those boundaries by pushing a case forward, the entire elaborate legal structure revealed itself to be fundamentally a negotiation and power relationship rather than any coherent code of universal laws. Václav lived for another 30 years, following his release never holding any official position again in either imperial or Bohemian administration, becoming essentially a living permanent reminder that law in multilingual empires was ultimately a language game, with no real winners, only survivors who learn to navigate the chaos. What does it fundamentally mean when the law and justice itself depends not primarily on what actually happened in objective reality, but rather on which specific language the presiding judge subjectively chooses to read and interpret the written law in on any particular day?